Well, thank you, Mr. Chairman. I want to start by acknowledging progress. I think it's important that we do so. This morning, we've had 9 straight Democrats talk to the FBI about emails without asking for immunity. That's a record. And I suspect the reason that they have not asked for immunity from Director Comey is they would say they've done nothing wrong. I find that interesting because that's exactly what Heather Samuelson and Cheryl Mills' attorneys said. In fact, they said it just a few days ago, and I'll quote it. The FBI considered my clients to be witnesses and nothing more. And then Ms. Mills and Ms. Samuelson's attorney said this. I think this is the most interesting part. The Justice Department assured us my clients did nothing wrong. Well, Mr. Chairman, if you're assuring subjects or targets or what witnesses, whatever you want to call them, that they've done nothing wrong, it does beg the question, what are you seeking and receiving immunity from? I mean, if you've done nothing wrong, laptops don't go to the Bureau of Prisons, Mr. Chairman. People do. So the immunity was not for the laptop. The immunity was for Cheryl Mills. And if the Department of Justice says you've done nothing wrong, it does beg the question of why you are seeking or receiving immunity. And it could be, Mr. Chairman, for a couple of different. It could be for the classified information that was the genesis of the investigation. It could be for the destruction of federal records, which came from that initial investigation, or it could be both. Mr. Comey, I want to ask you this. Did the Bureau interview everyone who originated an email that ultimately went to Secretary Clinton that contained classified information?
I don't think so. Nearly everyone, but not everyone.
Well, you and I had a discussion the last time about intent. You and I see the statute differently. My opinion doesn't matter. Yours does. You're the head of the Bureau. But in my judgment, you read an element into the statute that does not appear on the face of the statute. And then we had a discussion about intent. So why would you not interview the originator of the email to, number one, determine whether or not that originator had a conversation with the secretary herself?
There were a handful of people who the team decided it wasn't a smart use of resources to track down. One was a civilian in Japan, as I recall, who had forwarded something that somehow got classified as it went up, and the other were a group of low-level State Department people deployed around the world who had written things that ended up being classified. Nearly everyone was interviewed, but there was a small group that the team decided it isn't worth the resources.
Well, to that extent, if you interview the overwhelming majority of the originators of the email, will you make those 302s available to Congress? Because I counted this morning 30-something 302s that we do not have.
Okay. I'll go back and check. My goal is maximum transparency, consistent with our obligations under the law. I'll check on that.
Well, and I appreciate it for this reason. Intent is awfully hard to prove. Very rarely do defendants announce ahead of time, I intend to commit this crime on this date. Go ahead and check the code section. I'm going to do it. That rarely happens. So you have to prove it by circumstantial evidence, such as whether or not the person intended to set up an email system outside the State Department, such as whether or not the person knew or should have known that his or her job involved handling classified information, whether or not the person was truthful about the use of multiple devices, whether or not the person knew that a frequent emailer to her had been hacked, and whether she took any remedial steps after being put on notice that your email or someone who's been emailing with you prolifically had been hacked, and whether or not, and I think you would agree with this, Director, false exculpatory statements are gold in a courtroom. I would rather have a false exculpatory statement than a confession. I would rather have someone lie about something and it be provable that that is a lie, such as that I neither sent nor received classified information, such as that I turned over all of my work-related emails. All of that, to me, goes to the issue of intent. So I got 2 more questions, then I'm going to be out of time. For those who may have to prosecute these cases in the future, what would she have had to do to warrant your recommendation of a prosecution? If all of that was not enough, because all of that's what she did, if all of that's not enough, I mean, surely you cannot be arguing that you have to have an intent to harm the United States to be subject to this prosecution. I mean, that's treason. That's not a violation of this statute.
No, I think we'd have to be able to prove beyond a reasonable doubt a general awareness of the unlawfulness of your conduct. You knew you were doing something you shouldn't do. And then, obviously, that's on the face of the statute itself. Then you need to consider, so who else has been prosecuted and what circumstances, because it's all about prosecutorial judgment. But those two things would be the key questions. Can you prove that the person knew they were doing something they shouldn't do, a general criminal intent, general mens rea,
but the
way to treated other people similarly?
The way to prove that is whether or not someone took steps to conceal or destroy what they've done. That is the best evidence you have, that they knew it was wrong, that they lied about it.
It's very good evidence. Always want to look at what the subject said about their conduct.
Well, and there's a lot. There's a lot. If you saw her initial press conference, it all falls under the heading of false exculpatory statement. I'm out of time, Mr. Chairman, but the director did. You started off by giving us examples of things the Bureau has done. And every one of us who's worked with the FBI, that is the FBI that I know. The one that went and saved that girl in North Carolina, that is the FBI that I know. What concerns me, Director, is when you have 5 immunity agreements and no prosecution, when you are allowing witnesses who happen to be lawyers, who happen to be targets, to sit in on an interview. That is not the FBI that I used to work with. So I've been really careful to not criticize you. In fact, I said it again this morning. They wanted to know, was he gotten to? Did somebody corrupt him? No, I just disagree with you. But it's really important to me that the FBI be respected. And you got to help us understand, because it looks to me like some things were done differently that I don't recall being done back when I used to work with them. And with that, I would yield back to the chairman.
Can I respond to that?
Yes, you may.
I hope someday when the political craziness is over, you will look back again on this, because this is the FBI you know and love. This was done by pros in the right way. That's the part I have no patience for. Sorry, sir.
Thank you, sir. Chair, thanks. Gentleman, recognize the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. Professor Ramirez, you mentioned a couple of cases in your opening statement, and I know that time is short when you only have 5 minutes, and you were not able to address other cases. I wanted to ask you whether or not you were familiar with a few other cases. Sandy Rogers and Scotty Richardson from Aiken, South Carolina. You familiar with that case?
No, sir.
How about Roger Dale Rice from Lawrence, South Carolina? You familiar with that case?
No, sir.
Eric Nicholson or Marcus Whitfield from Greenville, South Carolina? You familiar with that case?
No, sir.
Russ Sorrow from Greenville, South Carolina?
No, sir.
Or Kevin Carper from Spartanburg, South Carolina?
No, sir.
Professor, those are just a handful of the more than 340 police officers who were killed in the line of duty in South Carolina. And Kevin Carper's case is most instructive because his partner did CPR on the suspect that killed Kevin, trying to save his life. Let me ask it another way. Are you familiar with the case of Ricky Samuel?
No, sir.
How about Tamika Houston?
No, sir.
How about Nell Lindsay?
No, sir.
Miranda All?
No, sir.
Santiago Rios?
No, sir.
Those are all folks that were the victim of intra-racial homicides in South Carolina. And I hasten to add, there were not protests either with any of those police officer killings or any of the intra-racial killings. And I suspect you agree with me, Professor, that all lives matter. Whether you're killed by a police officer or your next-door neighbor, you're every bit as dead, aren't you?
Yes, sir. I actually, as a former prosecutor and someone who's worked with police officers, have the deepest respect for them.
So do I. And despite that deep respect, Professor, I still maintain the objectivity of prosecuting police officers who engaged in misconduct. We have a process in place if you don't think you can be fair. It's called recusal. which is what some of us did in every single one of our officer-involved shootings. We recused it to another prosecutor so he or she could make that decision. So there is a process in place. You called for a process. There is one. It's called recusal. Do you know, as a former prosecutor, or can you deign what may have been the biggest impediment to our being able to successfully prosecute homicide cases, particularly homicide cases involving victims of color, in my criminal justice jurisdiction? Do you know what the biggest impediment was?
In Massachusetts, one of the biggest impediments is trying to get witnesses to come forward.
You're exactly right. You're exactly right. You have a victim of color, and we had trouble getting witnesses to cooperate with law enforcement and prosecutors, which then, as you know, diminishes the quality of that case and your ability to prosecute it, which may result in a lesser plea bargain because you don't have the facts, which may then result in what you said in your opening statement, which is people have a tendency to treat black lives differently than white, when the reality is the case wasn't quite as good. Isn't that a possibility too?
For every prosecutor who's out there, this is a serious problem, and you are correct in pointing that out, sir.
Right, and it wasn't just me pointing it out, Professor. I happen to have a fantastic chief of police when I was the DA. Fantastic man by the name of Tony Fisher, who happened to be an African-American chief of police. And he lamented the exact same thing you and I are talking about, is the loss of life in his community and the refusal of people to cooperate, even in a drive-by shooting of an 8-year-old at a birthday party. A drive-by shooting outdoors where the whole world saw the car drive by, and nobody would cooperate with the prosecution in the murder of an 8-year-old. So I hope that part of this 21st century police strategies conversation that we're having includes getting people to cooperate with law enforcement so you can hold people to the exact same standard regardless of the race of the victim. And I want to say this too. I want to thank my friend Ced Richmond and Hakeem Jeffries and others who are working on this issue because they want a justice system that is colorblind. After all, it's represented by a woman wearing a blindfold, so let's go ahead and make it colorblind. And both of those guys have worked really, really hard and will continue to do so, because let me tell you what my goal is. My goal is for witnesses to feel comfortable cooperating. But here's my other goal, and I'm out of time, but I'm going to share it with you. I want us to get to the point where we lament the death, the murder of a black female like Nell Lindsay, just as much if it's at the hand of an abusive husband, which it was, as we would if it had been at the hand of a white cop. I'd like to get to the point where we're equally outraged at the loss of life, and I hope we can get there. With that, I would yield back.
Chair, thanks. The gentleman recognizes the gentlewoman from Texas, Ms. Jackson Lee, for 5 minutes.
Our fellow citizens' frustration with government. They are absolutely convinced that we spend their money differently from the way that we would spend our own, and they are exactly correct. The rest of America cannot comprehend of a $44 breakfast. They are pouring generic brand cereal while you are eating a $44 breakfast. The rest of America would never conceive of a $7 Monte Cristo mini sandwich. And neither would you if you were spending your own money. You don't go out of your pocket and buy commemorative coins. I don't know anyone who does that. But we don't hesitate to spend taxpayer money on a trinket like that. Giving bicycles to indigent children is a wonderful idea. I hate that you robbed yourself of the satisfaction of knowing what it feels like to do it yourself instead of spending someone else's money to do it. The ostensible purpose of this hearing was to exchange ideas. You know, Alexander Graham Bell has this marvelous invention called a telephone. or better yet, video conferencing. The notion that you have to spend $800,000 to exchange ideas is laughable and perhaps criminal. And the part that galls me the most is the hypocrisy of GSA not even following its own damn rules. You are so quick to make everyone else follow the rules, and you can't follow your own rules. You have an event planner on staff. That'll come as quite a surprise to most taxpayers. What will come as even more of a surprise is the fact that you didn't even use them. You paid somebody else to plan the event despite the fact that you have event planners at taxpayer salary. And the scouting trips. You know, Mr. Chairman, the tribes of Israel sent 12 scouts into the Promised Land before they decided to invade, and GSA has to send 15 to Las Vegas to check out a hotel. Do you not see the outrage in that, Mr. Robertson? Do you see it?
Absolutely. This conference was outrageous.
Well, I'm not going to be as self-congratulatory as some other people are. I think the fact that we're having a hearing is a loss. Most people don't need a hearing to know that you don't spend other people's money the way that money was spent at this conference. We don't need a list of recommendations from the Inspector General. We don't need to be reminded that you can't negotiate a discount on a purse because the U.S. government decided to contract with a hotel. That is criminal. And a mind reader? My guess is they will not need a mind reader to find out the American public has lost confidence in the institutions of government. And the response, I want indictments, Mr. Inspector General. That's a great way to get people's attention, an indictment. Not a memo, not corrective measure, an indictment. I went through your report and I wrote 25 times, what's the penalty? What's the penalty for doing what you found that they did? What is the penalty for negotiating a discount on a purse for your personal use because you work for the government and you steered work? What's the purpose? What's the penalty for tipping off a competitor of another bid? That sounds remarkably criminal to me, Mr. Inspector General. Attack with possible terror links, correct?
Yes, sir, that's what I recall.
Did the President of Libya ever mention a spontaneous protest related to a video?
No, sir.
When Ambassador Stevens talked to you, perhaps minutes before he died, as a dying declaration, what precisely did he say to you?
He said, Greg, we're under attack.
Would a highly decorated career diplomat have told you or Washington had there been a demonstration outside his facility that day?
Yes, sir, he would have.
Did he mention one word about a protest or a demonstration?
No, sir, he did not.
So fast forward, Mr. Hicks, to the Sunday talk shows and Ambassador Susan Rice. She blamed this attack on the video. In fact, she did it 5 different times. What was your reaction to that?
I was stunned. My jaw dropped. And I was embarrassed.
Did she talk to you before she went on the 5 Sunday talk shows?
No, sir.
You were the highest ranking official in Libya at the time, correct?
Yes, sir.
And she did not bother to have a conversation with you before she went on national television?
No, sir.
So Ambassador Rice directly contradicts the evidence on the ground in Libya. She directly contradicts the president of Libya. She directly contradicts the last statement uttered by Ambassador Stevens. Mr. Hicks, who is Beth Jones?
Beth Jones is the Acting Assistant Secretary for Near Eastern Affairs at the State Department.
I want to read an excerpt from an email she sent, and you were copied on it. And by the way, Mr. Chairman, for our colleagues who like to trumpet bipartisanship, this would be a wonderful opportunity to demonstrate it. Some of these emails, even though they're not classified, have not been released, Mr. Chairman, including the one that I'm going to read from. So for my colleagues who trumpet bipartisanship, this would be a wonderful time to prove it. This is from Ms. Jones to you, to counsel for Hillary Clinton, to Victoria Nuland, to Mr. Kennedy, near as I can tell, to almost everyone in the State Department, and I'm going to read from it. I spoke to the Libyan ambassador and emphasized the importance of Libyan leaders continuing to make strong statements. By the way, Mr. Hicks, this email was sent on September the 12th, the day after Benghazi, and several days before Ambassador Rice's television appearance. And I'll continue. When he said his government suspected that former Gaddafi regime elements carried out the attacks, I told him that the group that conducted the attacks, Ansar al-Sharia, is affiliated with Islamic terrorists. Let me say that again, Mr. Hicks. She told him, the State Department, on September the 12th, days before our ambassador went on national television, is telling the ambassador to Libya, the group that conducted the attacks, Ansar al-Sharia, is affiliated with Islamic terrorists. Mr. Hicks, I want to know two things. Number one, why in the world would Susan Rice go on 5 Sunday talk shows and perpetuate a demonstrably false narrative? And secondarily, what impact did it have on the ground in Benghazi, the fact that she contradicted the president of Libya?
As to the first question, I cannot provide an answer, but perhaps you should ask Ambassador Wright.
I would love the opportunity to do just that.
As to the second question, at the time, we were trying to get the FBI to Benghazi to begin its investigation. And that talk show actually provided an opportunity to make that happen. Afterwards, we encountered bureaucratic resistance for a long period from the Libyans. The Libyan government at this time is not very deep. President, Prime Minister, Deputy Prime Ministers, ministers, all capable people. Some vice ministers as well. And it took us an additional see, my math's not very fast these days, maybe 18 days to get the FBI team to Benghazi.
So the crime scene was unsecured for 18 days.
Yes, sir.
Witnesses were not interviewed.
Would the gentleman would please finish up? We're going to try and move along.
Yes, I will move on. We will finish this if there is a second.
Yes, sir.
Witnesses were not interviewed.
Would the gentleman would please finish up? We're going to try and move along.
Yes, I will move on. We will finish this if there is a second round.
I hate to be cynical, but I think you're right. Ms. Gupta, you said you were a prosecutor. There was a question I got way back in time that I never really had a good answer for. Whenever a family member who had lost a loved one to an act of violence, to someone who was out on bond, would ask me, why was that person out of jail? I never really had a good answer. I mean, you can cite the Constitution that you're really entitled to bond absent some circumstances, but that's kind of a hollow explanation. So what would the explanation be to those who have lost loved ones to violent crime for people who are here unlawfully and the federal government knows it?
There is, for somebody who's been accused of a violent crime, the NOPD is absolutely entitled and in its authority to prosecute to the law to the fullest. And there's nothing in this policy.
You're either missing my point inadvertently or you're missing my point intentionally. I realize you prosecute people after the homicide. I'm trying to figure out how to prevent the homicide. What is the explanation for why the person wasn't dealt with before the murder?
Well, let me just, again, make clear that the reason we undertook the policy was to ensure that NOPD could fight violent crime, could get the kind of critical information from victims and witnesses who need to share critical crime information with the NOPD in order to solve and prevent violent crime in that
Well, Ms. Gupta,
jurisdiction.
you and I both know that we rely on all sorts of witnesses, some of whom, frankly, expose themselves to criminal liability in the process of cooperating. So the notion that you have to give amnesty to people before they will cooperate with law enforcement has not been my experience. But Attorney General Landry, I'm out of time. You asked the question. How do you answer it when family members ask you, why was this person not dealt with before they committed the act of violence? I never really had a good answer to that one.
Unfortunately, I've had to answer that question in Louisiana here lately. And the best way I answer them is that our system in this country is broken.
Mr. Gowdy for 5 minutes.
Good morning, Director Comey. Secretary Clinton said she never sent or received any classified information over her private email. Was that true?
Our investigation found that there was classified information sent.
So it was not true.
Right, that's what I said.
Okay. Well, I'm looking for a little shorter answer, so you and I are not here quite as long. Secretary Clinton said there was nothing marked classified on her emails, either sent or received. Was that true?
That's not true. There were a small number of portion markings on, I think, 3 of the documents.
Secretary Clinton said, I did not
3D.
email any classified material to anyone on my email. There is no classified material. Was that true?
There was classified material emailed.
Secretary Clinton said she used just one device. Was that true?
She used multiple devices during the 4 years of her term as Secretary of State.
Secretary Clinton said all work-related emails were returned to the State Department. Was that true?
No, we found work-related emails, thousands, that were not returned.
Secretary Clinton said neither she nor anyone else deleted work-related emails from her personal account. Was that true?
That's a harder one to answer. We found traces of work-related emails on devices or in Slack space, whether they were deleted or whether when a server was changed out, something happened to them. There's no doubt that there were work-related emails that were removed electronically from the email system.
Secretary Clinton said her lawyers read every one of the emails and were overly inclusive. Did her lawyers read the email content individually?
No.
Well, in the interest of time, and because I have a plane to catch tomorrow afternoon, I'm not going to go through any more of the false statements, but I am going to ask you to put on your old hat. False exculpatory statements, they are used for what?
Well, either for a substantive prosecution or for evidence of intent in a criminal prosecution.
Exactly. Intent and consciousness of guilt, right? Is that right?
Right.
Consciousness of guilt and intent. In your old job, you would prove intent, as you just referenced, by showing the jury evidence of a complex scheme that was designed for the very purpose of concealing the public record. And you would be arguing, in addition to concealment, the destruction that you and I just talked about, or certainly the failure to preserve. You would argue all of that under the heading of intent. You would also be arguing the pervasiveness of the scheme, when it started, when it ended, and the number of emails, whether they were originally classified or up-classified. You would argue all of that under the heading of intent. You would also probably, under common scheme or plan, argue the burn bags of daily calendar entries or the missing daily calendar entries as a common scheme or plan to conceal. 2 days ago, Director, you said a reasonable person in her position should have known a private email was no place to send and receive classified information. You're right, an average person does know not to do that. This is no average person. This is a former First Lady, a former United States Senator, and a former Secretary of State that the President now contends is the most competent, qualified person to be president since Jefferson.
He didn't say that in 08, but he says it now. She affirmatively rejected efforts to give her a state.gov account. She kept these private emails for almost 2 years and only turned them over to Congress because we found out she had a private email account. So you have a rogue email system set up before she took the oath of office, thousands of what we now know to be classified emails, some of which were classified at the time. One of her more frequent email comrades was in fact hacked, and you don't know whether or not she was. And this scheme took place over a long period of time and resulted in the destruction of public records, and yet you say there is insufficient evidence of intent. You say she was extremely careless, but not intentionally so. You and I both know intent is really difficult to prove. Very rarely do defendants announce, on this date, I intend to break this criminal code section. Just to put everyone on notice, I am going to break the law on this date. It never happens that way. You have to do it with circumstantial evidence. Or if you're Congress and you realize how difficult it is to prove specific intent, you will formulate a statute that allows for gross negligence. My time is out, but this is really important. You mentioned there's no precedent for criminal prosecution. My fear is there still isn't. There's nothing to keep a future Secretary of State or President from this exact same email scheme or their staff. And my real fear is this. It's what the chairman touched upon. This double-track justice system that is rightly or wrongly perceived in this country. That if you are a private in the Army and you email yourself classified information, you will be kicked out. But if you are Hillary Clinton and you seek a promotion to Commander-in-Chief, you will not be. So what I hope you can do today is help the average person, the reasonable person you made reference to, the reasonable person understand why she appears to be treated differently than the rest of us would be. With that, I would yield back.
Chair now recognizes himself for questions. Mr. Rubin, have you read the House resolution?
Pardon me. Yes, sir, I have.
What is your understanding of what this committee has been asked to do?
My understanding is that the committee has been asked to review the incidents related to the Benghazi attacks and all of the, as you described at the beginning, in all of the aspects that it seeks.
So your understanding is that we have been asked to look at all policies, decisions, and activities that contributed to the attacks?
Certainly, that's our understanding, and we support providing the information related to that request.
That affected our ability to prepare for the attacks?
But if that's ultimately the decision.
Well, you've read it, right? I mean, you've read the resolution, right? You're not disagreeing with my interpretation of the resolution, are you?
We defer to the committee's direction on how it wants to proceed.
Including executive branch efforts to identify and bring to justice the perpetrators of these attacks? Did you read that in the resolution?
Sir, I don't have it in front, so I can't quote it.
I'll be thrilled to get you a copy of the resolution. Sure. For the meantime, you're just going to have to take my word that it also says executive branch efforts to identify and bring to justice the perpetrators of these attacks. That's in the resolution. Can you tell me specifically how our interviewing witnesses is going to jeopardize the prosecution?
Sir, the Department of Justice has been clear with us.
I'm asking you. It was in your opening statement. I'm asking you. You tell me, a former prosecutor, how our interviewing witnesses that have already been interviewed by the ARB, already been interviewed by the Best Practices Panel, and frankly, already been interviewed by the State Department. The video that you showed us last week, that agent interviewed the witnesses in preparation for a video. So if the ARB and the Best Practices Panel and your own agency can interview people in preparation of a training video, how can Congress not interview those witnesses?
Sir, no one has said that Congress cannot interview.
You just said that it would jeopardize an ongoing prosecution, and I just asked you specifically how.
My understanding, and I am the chief liaison to the House for the State Department, is that our colleagues at the Department of Justice have been in touch.
Specifically, who told you that?
My colleagues within the State Department who work on this on a daily basis.
I'm looking for a name because I've got to clear up this misconception that simply talking to a witness who's already talked to 3 other investigatory bodies, that somehow or another Congress cannot talk to these witnesses, even though apparently everybody else can. I'm curious how that jeopardizes an ongoing prosecution.
Sir, I'm not an attorney. I'm not a prosecutor. What I am is the chief liaison to the House for the State Department. And what I am conveying is that the Justice Department has told us that this could have an impact, and they would like to have a conversation with you and your committee about that.
Do you believe that Congress has the constitutional authority to provide oversight?
Every day I do that with my job, yes, sir.
So you do agree with that. What is your interpretation of the phrase all policies, decisions, and activities?
In what context?
In any context. How about contributed to the attacks? What is your understanding of all policies, all decisions, all activities?
The approach that we are taking at the State Department is to provide materials to the committee at the direction of the committee. The request for interviews that you have reiterated here today, I am explaining that the Justice Department has said that they would like to have conversations with the committee for the concern about the protection of the welfare of these agents.
I want to ask you something. I want to ask you something, okay? Because there are 12 people up here who may not agree on another single solitary thing, but every one of us agrees that we don't want to do anything to jeopardize the physical security of anybody who works for this government, nor does anybody on this dais want to do anything to jeopardize an ongoing prosecution. Okay, can we stipulate that nobody
Certainly.
wants to do either of those things?
Certainly.
Will you also stipulate that you can talk to witnesses while preserving their identity and not jeopardizing an ongoing prosecution?
I am confident that in the conversations between the Justice Department and the committee that those modalities can be discussed. I
Mr.
am
Rubin,
not the expert on
Mr.
how
Rubin,
those modalities
do you see the Justice Department at this hearing?
No, sir.
Do you know why they're not at this hearing?
No, sir.
Because we don't have any issues with them. That's why they're not here. You just cited a reason to deny access to witnesses that even the Justice Department hasn't cited. So what I want you to do is help this committee gain access to precisely the same witnesses that everyone else, from the ARB to the best practices panel to your own agent who compiled a training video, had access to the witnesses.
Sir, as I said in my opening statement, we are happy to have the conversation with you and your staff on how to engage on this. And that is something that we're open to. We have never said no.
Well, and I appreciate that. I appreciate that. But I want to make sure that you and I have a clear understanding with each other. If 6 people observed an important event and you were being asked to write a final definitive accounting of that event, how many of the 6 would you want to talk to?
Sir, I understand.
That's not a trick question.
I know it's not a trick question, and I understand the point, and this is why we are here.
Well, if you understand the
why
point,
we provided the quantity of documents and worked in collegial terms.
Mr. Rubin, we're going to get to the quantity of documents in a minute. I noticed that you said 40,000. That's an impressive number. That's 40 copies of Dr. Zhivago. That's 40 copies of Crime and Punishment. That's a lot of pages. 40,000 out of how many? That's our question. How many documents? Is 40,000 half? Is it all? Is it 2/3?
We have made a comprehensive search, and as you know, the State Department spans 275 missions overseas, 70,000.
I do. I'm not asking you to bring any ambassadors back.
A comprehensive amount of.
I'm not asking you to bring any ambassadors back to search for emails. I'm not. Not a single one. How many employees does the State Department have?
Roughly 70,000.
70,000?
Correct.
All right. And we have asked for emails from 7th floor principals. Do you think that that is a reasonable request when you have been asked to study all policies, all activities, and all decisions?
In your committee's December letter, where it named principals, first, in fact, all of those principals there are emails, there are documents related to them in that 40,000. And in addition, you and your
Is it your testimony that we have all of the emails that we've asked for?
Well, you and your colleagues prioritize former Secretary Clinton's emails, and that is our priority, as I stated in my opening statement.
I would say multiple emails. If there are multiple email accounts, we want all of the emails.
And
okay?
we agree, and we are, as I
Well, you may have noticed my colleague from Maryland used the word glacial. I find the use of that word interesting when you vote against constituting a committee, when you threaten not to participate in the committee, when you continually threaten to walk away from the committee,
when you can't identify a single solitary person that you would issue a subpoena to, when you are prepared to have an ask and answered website before you got the 15,000 pages of documents that you just provided, when you expect members of Congress who are having conversations with people on airplanes to stop the conversation and say, let me go get a Democrat. You heard the word glacial. We're going to pick up the pace. We're going to pick up the pace. I have no interest in prolonging this. None.
Sir,
So
I
you're going to
assure
have
you
to pick up the
that
pace
we
with
do
us,
not,
okay?
Absolutely, and this is why we're here today. We have made 2 witnesses available since the fall of last year. We are prepared at any time, proactively, as you and your colleagues know.
I appreciate that, Mr. Rubin. Are you familiar with the subpoena that dates back to 2013 that the Oversight Committee sent with respect to the ARB?
Yes.
Okay. ARB is a statutory creation, you agree? Congress created the ARB?
Yes, it did.
Do you agree Congress can amend or alter or enhance the ARB? If it's a
through an act
statute,
of
sure.
Congress
can change it, right? You agree Congress should provide oversight over one of its statutory creations?
Yes, sir.
How can we do that if you will not give us the documents related to the ARB? How can we possibly do that, Mr. Rubin?
Sir, first, of the 40,000 pages of documents that the committee has received, many of those are, in fact, related to the ARB.
Mr. Rubin, I appreciate, I really do. I really do. I appreciate the word many. I appreciate the 40,000. I keep coming back to one word that's in the House resolution, and that word is all.
So, sir,
do we have all of the documents?
What we have communicated to you and to your staff, and what we've been grateful for, is the committee's explanation of its top priorities. And we would be very honored to continue to have those discussions. If the ARB, as you've noted here, becomes the top priority,
well,
that is certainly...
Mr. Rubin, we shouldn't have to pick among priorities. You have 70,000 employees. I mean, what we're not going to do is identify one tranche of emails and then 2 months later go depose or do a witness interview with that witness, and then 2 months later get another tranche of emails. When our colleagues on the other side, who, by the way, had no interest in forming this committee whatsoever, but are now ironically complaining about the pace of a committee that they had no interest in forming whatsoever, it's time for us to pick up the pace. And I'm looking to you to help me do that.
And that's why we're here, and that's why we have continually engaged proactively with you and your committee, and we're happy to continue to do so.
Okay.
And I would mention the 70,000 employees are engaged in their jobs.
I appreciate that. I don't want any ambassadors, security guards. I don't want anybody taken off of an important job. But compliance with congressional inquiries is important, and if you have time for condom demonstrations or culinary diplomacy, I think you have time to comply with a legitimate request for documents from Congress, and I'm sure you agree. And with that, I would recognize the gentleman from Maryland. Bishop, you decried the use of generalities in describing the immigrant population right before you then used a generality of 12 million. You repeated the same talking point straight out of the DNC. 12 million aspiring citizens. I'm assuming that you are not counting the killer of Miss Wilkerson's son in that 12 million.
I'm not understanding your question.
Well, you said there's 12 million aspiring Americans here, and my point is all 12 million aren't aspiring, and all 12 million couldn't pass any background check, even one by the ACLU or a criminal defense attorney. Surely you're not including the person that killed her son in the 12 million aspiring Americans.
I'm not sure that I used the term aspiring.
Well, you said 12 million. You spoke as if the entire population is deserving of citizenship. That's precisely what you said.
I do believe that the 12 million who are here need to be considered for a pathway to
How about the one that killed her son?
Citizenship.
How about the one that killed her son?
He's a criminal. I hope he's been dealt with as a criminal.
So it's 12 million minus one. How about the one that killed?
Community.
Again, it's 12 million minus one. How about the one that killed Miss Root's daughter?
That's a criminal case.
All right, so that's
and
12 million minus
immigration
2.
Policy.
How about the gang members in Sheriff Jenkins' jurisdiction?
If we're talking about safety in our communities, then let's
talk
about safety
the gang
in our
members in
communities.
Sheriff Jenkins' jurisdiction? Are those part of the 12 million with which you made reference?
I do not know. What I do
You don't know whether or not
what
a
I
gang
do
member
know-
should be included on a path to
What I
citizenship?
do know is that our communities deserve greater safety, and it's
No,
not
ma'am.
going to happen when we pit
I just
victims
respectfully
against victims.
disagree with you, Bishop. American citizens should not be victimized by crime. I think we can agree with that. And American citizens should not have to wait until someone who is not here legally commits another crime before we decide to get serious about enforcing our immigration laws. So my question to you is this. Of the 12 million, if that number is right, minusing the one that killed Miss Wilkerson's son, minus the one that killed Miss Root's daughter, minus the gang members, minus the 300,000 that have already been adjudicated to have committed another criminal offense, how would you go about identifying the good ones from the bad ones?
The way we identify good ones from the bad ones every single day, by looking at their character, by seeing how they're
Well, how are we supposed to do that if we don't even know who they are, Bishop?
Well, we won't know who they are if we continue to treat them the way we're treating them now.
No. There's a way to know. There's a but you just said you don't like the way that we've chosen to do it. You don't want local law enforcement.
I do not think that that is a helpful way.
Well, let me ask you this,
Immigrant
Bishop.
communities want to help. They want to
why
keep their
don't
community
you-
safe, but they won't come forward if they think that they're going to be picked up by us.
Oh, no,
if it's going to threaten their lives.
We
if
saw
their
a
children are
perfect
going to be
example.
left behind.
It's going to be really tough for the court reporter if you continue to talk while I'm asking questions. She's got a tough enough job. So how about we just agree to go one at a time, okay? How about Kate Steinley's murder in San Francisco? That's a sanctuary city. You wrote an op-ed on it. Do you remember that?
I did.
And you advocated for policies that prevent gun violence. You remember writing that?
Yes.
We have some of those policies. In fact, we call them laws. There's a law against shooting someone on a pier who's walking beside her father. We already have that law. We already have a law where convicted felons can't purchase or possess firearms. Do you know that Kate Steinley's killer was a convicted felon?
Yes.
We also have a law that if you're not here legally, either overstayed a visa or crossed the border without permission, that you cannot legally possess or purchase a firearm. Did you know that was already
Yes.
a law? So what policies are you advocating for that would have saved Kate Steinley's life in addition to the ones we already have?
That's a very tragic situation, but you cannot blame all immigrants, documented
I'm not. I'm just blaming the one that
for the
shot her.
action of one person.
No.
That's what you are doing.
Your approach is to wait until the murder and then do the deportation. And my approach is try to have as few body bags as we can possibly have. Try to identify those that are not aspiring citizens before they kill somebody's son or daughter in San Francisco. That's my objective, to identify them before the crime. So my question to you is, how are you going to do that?
I would argue that we need trust policies where immigrants, documented and undocumented, can come forth to report crimes and to report when they too have been victims of crimes without the fear of being deported. We need that kind of trust. Otherwise, these families will not come forth. Immigrants do not want gangs in this country or in their communities. Many of them are
you don't hear
escaping
me
those
talking in
gangs.
generalities, Bishop. That was you that did that. I made a point in my opening of saying that we shouldn't be talking in generalities. I do find it bitterly ironic that you are talking about trust among the immigrant community, and you don't even trust local law enforcement to enforce our immigration laws. I find that richly ironic. Why don't you trust local law enforcement to enforce our immigration laws?
I do not trust the procedures and policies under which we are expecting governance and policing to happen in our communities.
Bishop, you trust them in murder cases. You trust them in child sex abuse cases. You trust them in narcotics cases. You trust them in kidnapping cases. You trust them in traffic violation cases. You trust them in every category of crime, except you just don't want the sheriff enforcing immigration laws. And yet you want to talk about building trust with the law enforcement community, and you don't trust him to enforce immigration laws, even though you trust him to enforce every other category? And you want to talk about trust. Did I hear you right?
I want to talk about trust policies, yes.
Well, I want to talk about the law. I want to talk about the law. You said we're a nation of immigrants. That may be true. we're also a nation of laws. And the ability to pick and choose the ones that you want based on political expediency or your view of theology is going to undermine this republic very quickly. And as a result, we'll have more panels with more moms. With
Laws
that,
of this country change when we realize that they're immoral or unjust.
well, then you can run for Congress and change the law. But as it stands right now, we're going to enforce it. If you don't like the law, you can change it. But what you can't do is just selectively decide which ones you want to enforce and which ones you don't, because that's called anarchy.
Congressman, we have broken immigration policies. That's what needs to be addressed.
Okay? But you just sat there and listed all the laws that we passed to try to address it. You didn't like a single one of them. You didn't like the law. You didn't like the law empowering local law enforcement. You don't like the fact that we would deny federal funding to sanctuary cities that harbor people like the man who killed Kate Steinle. So it's not a question of passing laws, Bishop, with all due respect. It's a question of passing laws you like.
It's a question of passing laws that are just.
All right, and if there's anything more relative in the world than the word just, I don't know what it is. So rather than aspire to justice, I'm just going to aspire that we actually enforce the law, because that is the community's manifestation of justice. We take what we think about justice and mercy, and then we codify it in something we call the law. And by the way, Bishop, these aspiring citizens that you talk about, the 12 million minus 1, 2, God knows how many, in their oath of citizenship, there are a half dozen references to the law. A half dozen references to the law in the oath that we expect new citizens to take. I think it'd be a really neat idea if we actually enforced the law so that citizenship oath actually had a little bit of meaning, because right now it doesn't seem to.
The gentleman from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. To the families of the victims, it's been 8 months. And I know that there are those who have said that's a long time ago. But the good news is there is no statute of limitations when it comes to finding out the truth, particularly for those who have served and sacrificed and died under our flags. So, Mr. Hicks, let's find out the truth. The President of Libya responded to the attack and labeled it an attack by Islamic extremists, possibly with terror links, correct?
Yes, sir.
So hours after our ambassador and 3 others are killed in Benghazi, the President of Libya says it was an attack with possible terror links, correct?
Yes, sir, that's what I recall.
Did the President of Libya ever mention a spontaneous protest related to a video?
No, sir.
When Ambassador Stevens talked to you, perhaps minutes before he died, as a dying declaration, what precisely did he say to you?
He said, Greg, we're under attack.
Would a highly decorated career diplomat have told you or Washington had there been a demonstration outside his facility that day?
Yes, sir, he would have.
Did he mention one word about a protest or a demonstration?
No, sir, he did not.
So fast forward, Mr. Hicks, to the Sunday talk shows and Ambassador Susan Rice. She blamed this attack on a video. In fact, she did it 5 different times. What was your reaction to that?
I was stunned. My jaw dropped, and I was embarrassed.
Did she talk to you before she went on the 5 Sunday talk shows?
No, sir.
You were the highest-ranking official in Libya at the time, correct?
Yes, sir.
And she did not bother to have a conversation with you before she went on national television?
No, sir.
So Ambassador Rice directly contradicts the evidence on the ground in Libya. She directly contradicts the President of Libya. She directly contradicts the last statement uttered by Ambassador Stevens. Mr. Hicks, who is Beth Jones?
Beth Jones is the Acting Assistant Secretary for Near Eastern Affairs at the State Department.
I want to read an excerpt from an email she sent, and you were copied on it. And by the way, Mr. Chairman, for our colleagues who like to trumpet bipartisanship, this would be a wonderful opportunity to demonstrate it. Some of these emails, even though they're not classified, have not been released, Mr. Chairman, including the one that I'm going to read from. So for my colleagues who trumpet bipartisanship, this would be a wonderful time to prove it. This is from Ms. Jones to you, to counsel for Hillary Clinton, to Victoria Nuland, to Mr. Kennedy, near as I can tell, to almost everyone in the State Department, and I'm going to read from it. I spoke to the Libyan ambassador and emphasized the importance of Libyan leaders continuing to make strong statements. By the way, Mr. Hicks, this email was sent on September the 12th, the day after Benghazi, and several days before Ambassador Rice's television appearance. And I'll continue. When he said his government suspected that former Gaddafi regime elements carried out the attacks, I told him that the group that conducted the attacks, Ansar al-Sharia, is affiliated with Islamic terrorists. Let me say that again, Mr. Hicks. She told him, the State Department, on September the 12th, days before our ambassador went on national television, is telling the ambassador to Libya, the group that conducted the attacks, Ansar al-Sharia, is affiliated with Islamic terrorists. Mr. Hicks, I want to know two things. Number one, why in the world would Susan Rice go on 5 Sunday talk shows and perpetuate a demonstrably false narrative? And secondarily, what impact did it have on the ground in Benghazi, the fact that she contradicted the president of Libya?
As to the first question, I cannot provide an answer, but perhaps you should ask Ambassador Rice.
I would love the opportunity to do just that.
As to the second question, at the time, we were trying to get the FBI to Benghazi to begin its investigation. And that talk show actually provided an opportunity to make that happen. Afterwards, we encountered bureaucratic resistance for a long period from the Libyans. The Libyan government at this time is not very deep. President, Prime Minister, Deputy Prime Ministers, ministers, all capable people, some vice ministers as well. And it took us an additional see, my math's not very fast these days, maybe 18 days to get the FBI team to Benghazi.
So the crime scene was unsecured for 18 days?
Yes, sir.
Witnesses were not interviewed?
If the gentleman would please finish up, we're going to try and move along.
Yes, I will move on. We will finish this if there is a second round. Thank you, Mr. Hicks.
Thank you. For all individuals, to the extent that
Ms. Parisi, how many visa overstayers are there in the United States?
Sir, as I said earlier, I don't have that statistic with me.
Well, let's use the President's statistics. If there are 11 million and 40% of them would be visa overstayers as opposed to border crossers, do you take exception with what the President said, or can we just use that as kind of a baseline?
I, in all honesty, don't recall what the President said about it, but I'm not sure where those stats are coming from.
So you cannot tell me how many visa overstayers are in the United States.
I don't have that information with me.
Is there a list?
There is an interim draft entry-exit report which has overstayed data in it.
No. I want, are there a list of names of visa overstayers?
So anybody who's overstayed, regardless if it's a visa or a visa waiver program, those individuals have final removal orders, and our Immigration and Customs Enforcement Agency receives that list.
So there's a list?
Yeah.
Is that list shared with federally licensed firearms dealers?
I am not sure.
Well, it is actually currently against the law for anyone who is here illegally or unlawfully to possess or purchase a firearm. And I understood in Mr. Good's opening, he wants to create a new list of prohibited persons, which just struck me that maybe we ought to find out how good a job we're doing with the current statutes that we have. Do you know how many prosecutions that there were for, say, the last 3 years for folks who tried to purchase a firearm that were not here legally?
No, sir, but I can ask ICE that question.
Well, it wouldn't be ICE, it'd be the Department of Justice.
Then I wouldn't have that information because I'm with DHS.
Well, and the good news for us is we do have that information, and it's an incredibly small number of prosecutions, like less than 100. So you can understand some of our skepticism when we hear folks calling for a new category of prohibited persons that cannot purchase or possess firearms when we've done such a dreadful job with the current categories. It is currently unlawful, illegal for people who are not legally in the country to purchase or possess firearms. And my question is, how many of those folks have we prosecuted? And the number's really small. Let me ask you another question about the terrorism list. What process is afforded a U.S. citizen, not someone who's overstayed a visa, not someone who crossed the border without permission, but an American citizen? What process is currently afforded an American citizen before they go on that list?
I'm sorry, there's not a process afforded the citizen prior to getting on the list. There is a process should someone feel they are unduly placed on the list.
Yes, there is. And when I say process, I'm actually using half of the term due process, which is a phrase we find in the Constitution, that you cannot deprive people of certain things without due process. So I understand Mr. Good's idea, which is wait until your right has been taken from you and then you can petition the government to get it back. I understand that that's his idea. My question is, can you name another constitutional right that we have that is chilled until you find out it's chilled and then you have to petition the government to get it back? Is that true with the First Amendment?
Sir, there are strict criteria before.
That's not my question, ma'am. That is not my question. My question is, what process is afforded a United States citizen before that person's constitutional right is infringed? Then he's fine with doing it with the Second Amendment. My question is, how about the First? How about we not let them set up a website or a Google account? How about we not let them join the church until they can petition government to get off the list? How about not get a lawyer? How about the Sixth Amendment? How about you can't get a lawyer until you petition the government to get off the list? Or my favorite, how about the Eighth Amendment? We're going to subject you to cruel and unusual punishment until you petition the government to get off the list. Is there another constitutional right that we treat the same way for American citizens that we do the Second Amendment? Can you think of one? Can you think of one?
I don't have an answer for you, sir.
All right, well, I'm out of time, but I've got a couple other questions, and I'm sure the chairman will indulge me. Do you know whether the female terrorist in California was subjected to an in-person interview before her K visa was issued?
As part of the visa process, yes, that individual was interviewed.
Do you know who interviewed the person?
I do not have that information. That would be a question to ask the State Department.
Do you know how long the interview took place, how long it lasted?
That would also be a question for the State Department. They conducted the interview.
Do you know what investigation, if any, was done into her in terms of education, employment, social media?
Those are all questions that should be referred to the State Department.
Who has her immigration file?
USCIS would have the immigration file.
I thought USCIS was a subset of DHS.
Yes.
And you're with DHS, so why wouldn't I ask you?
So the process would start with CIS for a K-1 visa.
I know, and then it goes to the State Department.
And then it goes to the State Department, which is where all the checks to see if that individual is eligible for the K1 visa. I'm sorry, I even lost my own train of thought.
No, I know, I know exactly where you're
if
going.
someone is eligible, sorry, for the K1
Mr. Rodriguez
visa.
was with us yesterday.
Yes. Then the individual would travel to the United States. Of course, there's vetting done on the individual as they travel, as any individual is. And then within 90 days, they can apply for legal permanent residency. And then that is also when USCIS would get involved and do biographic and biometric checks.
I understand the process, and I'm out of time. I'm just going to make this point before I yield back to the chairman. There's an application process for, we're not even talking about the visa waiver program. We're talking about the process where there actually is a visa issued. There's an investigation, there's an interview, there's another interview, and yet we still got it wrong. And I would think the chairman, one of whom is sitting beside me, and Chairman DeSantis and Ranking Member Lynch, I would think that they would be very interested in her immigration file to find out what questions perhaps weren't asked that should have been, so we can learn lessons after the 14 are dead, and hopefully we can learn before there are 14 more dead. So I would encourage you to ask your boss to make that file available to both the ranking member of the full committee, the chairman of the full committee, the ranking member of the subcommittee, and the chairman of the subcommittee. And with that, I would thank you, Mr. Chairman. Judge Craftsher, I'm going to read you a quote, and you tell me whether or not you know who said this, okay? 100% of the women at call centers have been abused. It's an atmosphere of abuse. Anytime we see a call center person, female, all have been abused. Do you know who said that, Judge?
I did. It was taken out of context.
Well,
sir, your microphone. Can you repeat that, sir?
Yes.
He said it was taken out of context. Well, let's put that in context. Judge, was that, did somebody testify to that at a lower level? Was that in the record?
No, sir. That was my experience.
Did you rely on a learned treatise? You made a point of saying in your opening statement how much respect you pay to the federal rules and the Constitution. Was that a learned treatise you relied upon, Judge?
No, that was my experience over 20
So you
years.
made yourself a witness even though the federal rules are very clear that judges are not witnesses. Is that what your testimony is, Judge?
That was my opinion, not any others.
100% of female employees at call centers have been abused.
I didn't say that. 100% of the people that appeared before me have been abused.
And you relied on no learned treatise, no testimony at a lower level, just your innate sense of medicine?
No, that's been my experience having hearings.
Well, let me ask you about another one of your experiences, Judge. I want to read you another quote and ask you whether or not you recognize who said this, okay?
Mm-hmm.
How did your family discipline you? Did they hit you on the butt? I'm starting to do some analysis. It's starting to be when women are hit at an early age, they start developing problems in their 20s, late teens and 20s. My ex-wife told me about this. There's something in a girl that's a sexual thing. It arouses certain things. Did you say that, Judge?
Yes, I did.
Did you rely upon a learned treatise in reaching that determination?
No, I relied on...
Did you rely on something at a lower level, a hearing, a witness testified to that?
No, I relied on my experience hearing case over 20 years.
Judge, I hasten to add, because you made a point of saying in your opening statement that your first responsibility is to the Constitution and the Federal Rules of Evidence. Are you aware that judges can't be witnesses? Are you familiar with that, Judge?
I don't consider myself a witness.
You just testified to your own personal experience. If that's not a witness, what is it?
That's a personal opinion.
Judges can't express personal opinions either. That's why we have something called experts.
So that's
Did an expert testify to that, Judge?
That's called a First Amendment right.
You're considered, so you have a First Amendment right to say whatever the hell you want in a hearing. Is that what you're saying?
No, sir.
And you can rely upon that when you're spending taxpayer money?
No, sir. But that's an isolated case.
Well, it can't be an isolated case. I just cited two.
Yeah.
And my colleagues cited others.
Yeah. You're taking isolated cases. I've had...
let's go a little broader than that, Judge. What is your reversal rate of the hearing officer? Is it in excess of 90%?
Yes, it's based upon testimony given to me.
All right, and it has to be adjudicated twice before it gets to you, right?
That's correct.
And only if it's denied does it get to you. So 90% of the time, the people under you are wrong.
No, I want to be able to cross.
Well, it has to be, or you wouldn't be reversing them. They've denied benefits, Judge, and you've reversed their denial. That means that you're hiring some really dumb people to be hearing officers because they're wrong 90% of the time.
No, sir. I want to be able to cross-examine the people from Social Security.
I'm glad you mentioned cross-examination.
Right.
I can't tell you how glad I am.
Yeah.
Because in every other court proceeding, there is someone cross-examining the witnesses, but it's not a judge. It's an attorney, and that's true in misdemeanor crimes, that's true in felony crimes, that's true in civil cases. So what I think you need, Judge, is I think you need an advocate and an attorney for the taxpayer in the hearing room. Because I don't want you cross-examining witnesses. If you really think that paddling a child leads to sexual issues, I don't want you doing the cross-examination. And if you really think that 100% of CNAs have been abused and 100% of females in call centers have been abused, I don't want you doing the cross-examination, Judge.
Sir, we wear three hats. One hat is the Social Security hat. The other hat is the claimant's hat. The other hat is the Social Security hat.
Where's the expert witness hat? You just said you were an expert witness.
We have an adversary system, and I have the right.
It's not an adversary system. There's no advocate for the taxpayer that's in the courtroom.
We have a non-adversary system, sir. It's a non-adversary system, and I have to wear three hats.
It can't be too adversarial, or you would not reverse the hearing officer 90% of the time. And some of your colleagues, 99% of the time, they reverse a hearing officer. And we mistakenly, Judge, thought it was because you were eyeballing the witnesses so you could assess credibility. But we learned from your colleague, Mr. Taylor, that that's not even true. Sir, you don't even have a hearing. You just do it on the paper.
Sir, it's not eyeballing the witness. I take testimony. I have had here, this sheet has...
And who does the cross-examination?
It has 186 ailments on it.
Who does... Well, that's your document. Mr. Cummings,
no.
Mr. Cummings just exposed it. That's your document.
No. The attorney also provides one for me.
The attorney for whom?
For the claimant.
That's my point. There is no attorney for the taxpayer. We're going broke. Mr. Chairman, I know I'm out of time, but I'm going to tell you a story from Spartanburg real quickly. I had a judge call me. He's apolitical. And he said, I just sentenced someone for calling under people's houses and stealing their copper. And he said, what really struck me as being unusual, Trey, is he is 100% disabled in the back. I want you to think about that, Judge, and I want you to think about one other thing, too. I went on a tour of something called a workability center, where people with special needs value work enough that they go to work every single day. And there was one man who was confined to a wheelchair, had no use of his hands or legs, but his job was to encourage his fellow employees. There is inherent value in work. And one reason your backlog may be so big is because it's so damn easy to get benefits.
Not for me. Not for me. I hear every case. I see every person that's ever appeared before me. Everyone.
You reverse the hearing officer over 90% of the time, Judge. 90% of the time, the person at the first level is wrong in your judgment, and you are citing your own version of medicine. 100% of the people are abused. That if you paddle a little girl, she's going to wind up with sexual issues, despite the fact it's not in the record, Judge. Well, you may be a judge, but you're not God.
Well, let me explain to you. If I had this person in front of me that was down below, I can examine him on behalf of Social Security, and that would allow the claimant's rep.
Well, then why don't your colleagues have hearings? Why do they do it on the paper? If it's that important to eyeball a witness and assess credibility and cross-examine them, why are you doing it on the paper?
That's what I said in my remarks here. We need the ability to be able to have the witnesses who give any comment down below should be appear before me, so I can examine them, and they can be cross-examined by the.
I want them being cross-examined by an advocate for the taxpayer, Your Honor, with all due respect, not a judge.
Well, they need an adversary system, which we don't have today.
Mr. Horsford.
The other hat is the claimant's hat. The other hat is is the Social Security hat.
Where's the expert witness hat? You just said you were an expert witness.
We have an adversary system, and I have the right.
It's not an adversary system. There's no advocate for the taxpayer that's in the courtroom.
We have a non-adversary system, sir. It's a non-adversary system, and I have to wear three hats.
It can't be too adversarial, or you would not reverse the hearing officer 90% of the time. And some of your colleagues, 99% of the time, they reverse a hearing officer. And we mistakenly, Judge, thought it was because you were eyeballing the witnesses so you could assess credibility. But we learned from your colleague, Mr. Taylor, that that's not even true. Sir, you don't even have a hearing. You just do it on the paper.
Sir, it's not eyeballing the witness. I take testimony. I have had here, this sheet has...
And who does the cross-examination?
It has 186 ailments on it.
Who does... Well, that's your document. Mr. Cummings, Mr. Cummings just exposed it. That's your document. That's
the attorney also provides one for me.
The attorney for whom?
For the claimant.
That's my point. There is no attorney for the taxpayer.
Good.
Thank you, Mr. Chairman. Judge Craftsher, I'm going to read you a quote, and you tell me whether or not you know who said this, okay? 100% of the women at call centers have been abused. It's an atmosphere of abuse. Anytime we see a call center person, female, all have been abused. Do you know who said that, Judge?
I did. It was taken out of context.
Well,
sir, your microphone, can you repeat that, sir?
Yes.
He said it was taken out of context. Well, let's put that in context. Judge, did somebody testify to that at a lower level? Was that in the record?
No, sir, that was my experience.
Did you rely on a learned treatise? You made a point of saying in your opening statement how much respect you pay to the federal rules and the Constitution. Was that a learned treatise you relied upon, Judge?
No, that was my experience over 2
So you made yourself a witness even though the federal rules are very clear that judges are not witnesses. Is that what your testimony is, Judge?
That was my opinion, not others.
100% of female employees at call centers have been abused.
I didn't say that.
The Constitution and the federal rules of evidence. Are you aware that judges can't be witnesses? Are you familiar with that, Judge?
I don't consider myself a witness.
You just testified to your own personal experience. If that's not a witness, what is it?
That's a personal opinion.
Judges can't express personal opinions either. That's why we have something called experts.
So
Did an expert testify to that, Judge?
That's called a First Amendment right.
You're considered, so you have a First Amendment right to say whatever the hell you want in a hearing. Is that what you're saying?
No, sir.
And you can rely upon that when you're spending taxpayer money?
No, sir. But that's an isolated case.
Well, it can't be an isolated case. I just cited two.
Yeah.
And my colleague cited others.
Yeah. You're taking isolated cases. I've had.
Let's go a little broader than that, Judge. What is your reversal rate of the hearing officer? Is it in excess of 90%?
Yes, it's based upon testimony given to me.
All right, and it has to be adjudicated twice before it gets to you, right?
That's correct.
And only if it's denied does it get to you. So 90% of the time, the people under you are wrong.
No, I want to be able to cross.
Well, it has to be, or you wouldn't be reversing them. They've denied benefits, Judge, and you've reversed their denial. That means that you're hiring some really dumb people to be hearing officers because they're wrong 90% of the time.
No, sir. I want to be able to cross-examine the people from Social Security.
I'm glad you mentioned cross-examination.
Right.
I can't tell you how glad I am.
Yeah.
Because in every other court proceeding, there is someone cross-examining the witnesses, but it's not a judge. It's an attorney, and that's true in misdemeanor crimes, that's true in felony crimes, that's true in civil cases. So what I think you need, Judge, is I think you need an advocate and an attorney for the taxpayer in the hearing room. Because I don't want you cross-examining witnesses. If you really think that paddling a child leads to sexual issues, I don't want you doing the cross-examination. And if you really think that 100% of CNAs have been abused and 100% of females in call centers have been abused, I don't want you doing the cross-examination, Judge.
Sir, we wear three hats. One hat is the Social Security hat. 100% of the people that appeared before me have been abused.
And you relied on no learned treatise, no testimony at a lower level, just your innate sense of medicine?
No, that's been my experience having hearings.
Well, let me ask you about another one of your experiences, Judge. I want to read you another quote and ask you whether or not you recognize who said this, okay?
Mm-hmm.
How did your family discipline you? Did they hit you on the butt? I'm starting to do some analysis. It's starting to be when women are hit at an early age, they start developing problems in their 20s, late teens and 20s. My ex-wife told me about this. There's something in a girl that's a sexual thing. It arouses certain things. Did you say that, Judge?
Yes, I did.
Did you rely upon a learned treatise in reaching that determination?
No, I relied on.
Did you rely on something at a lower level, a hearing, a witness testified to that?
No, I relied on my experience hearing case over 20 years.
Judge, I hasten to add, because you made a point of saying in your opening statement that your first responsibility is to...
We'll now recognize the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. Administrator Leonhardt, if an agent stateside were soliciting a prostitute that was provided by a drug conspiracy he was investigating, what punishment would you recommend?
I can't recommend a punishment. I would just hope that would be thoroughly investigated. And
so you're telling me nobody cares what the administrator of the DEA thinks should happen to an agent? You're powerless to express your opinion. You have no First Amendment right when it comes to who works for your agency.
I have expressed my opinion in a number of ways.
What did you express? What did you think the proper sanction was?
Last year, I sent email and I sent a memo to every employee in DEA and put them on notice that this kind of conduct was not acceptable.
My question must have been ambiguous, because I wasn't talking about future conduct. I was talking about past conduct. What punishment did you recommend for conduct that happened in the past?
Under the civil service law, I cannot recommend a penalty. I can't intervene in the disciplinary process. I can't even make a recommendation.
What does it take to get, what would it, hypothetically, what would it take to get fired as a DEA agent? Because the agents I used to work with were worried about using their car to go pick up dry cleaning. They were actually worried about using their OGV to pick up dry cleaning. They were worried about being disciplined. So apparently that world has changed. Do you know whether any of the prostitutes were underage?
I don't know that.
Would that impact whatever recommendation you might have in terms of a sanction?
I don't recommend the sanction. I can't fire. I can't recommend a penalty. There's a guide that the deciding officials abide by, and they have a penalty guide that they look at. And the penalty guide for this kind of activity is anything from reprimand to removal.
How about security clearance? Do you have any impact over that, whether or not an agent has a security clearance?
No, there's adjudicative guidelines, and that has to be adjudicated by the security people.
What power do you have? You have to work with agents over whom you can't discipline and have no control, and you have no control over the security clearance. What the hell do you get to do?
What I can do is build on and improve mechanisms to make sure that the outcome is what we believe the outcome should be. And that is what happened in Cartagena. That is what's going to happen moving forward.
Inspector General Horowitz, I find that stunning. Let me ask you this. Did the agents know that the cartels were providing the prostitutes?
What we found, Congressman, from looking in the file was that they should have known, given their trained law enforcement agents, and they were dealing with corrupt law enforcement, local law enforcement, that was providing them with the prostitutes as well as the various gifts.
Were they supposed to be investigating these cartels?
They were.
So they are receiving prostitutes from cartels that they are supposed to be investigating. And she can't fire those agents. You agree with her? She can't fire them?
I think as a matter of Title V, she can't directly intervene and fire them. I do think one of the concerns we outline in the report as to DEA and the other 3 agencies is how they adjudicate these cases. They undercharge them in some instances. And so at DEA, for example, sexual harassment, if you're charged with that, there's only one punishment: removal. But if you're charged with conduct unbecoming or poor judgment, which isn't even actually a category, then you've got a range of penalties. And so one of the issues, as you know as a former prosecutor, is how you charge the case. and that has a consequence.
Well, Mr. Chairman, I don't know what would need to be done, but I, like my friend from South Carolina, find it stunning that you can solicit prostitutes. Administrator Leonhardt, do we know whether any of the prostitutes were underage? Do we know whether any of them were part of any human trafficking rings?
Because the Bogota case happened a decade ago, there were no interviews of prostitutes. On the more recent one, the Cartagena one, it did not identify an age for the prostitute involved.
Mr. Chairman, I would just find it impossible to explain to any reasonable-minded person how an agent cannot be disciplined for soliciting prostitutes from drug cartels that they were ostensibly investigating. I find that stunning.
If the gentleman will yield, if somebody murdered somebody, could you fire him?
If someone murdered someone, there would be criminal charges, and that's how they'd be fired.
But if they were, could you take away their security clearance?
The Office's security programs can review security clearances and take their clearances, just as they did with the 3 agents in the Cartagena incident.
Gentleman from South Carolina.
The gentleman yield for just a second. I'm sorry, I heard you say that there's one thing you could actually fire somebody for, which is sexual harassment. So let me see if I get this correct, Mr. Horowitz, Mrs. Leonhardt. If I flirt with a coworker in the office and that constitutes sexual harassment, I can be fired, but I can take an underage hooker from a cartel I'm investigating, and you can't fire me. Is that what we're talking about here?
Actually, Congressman, if you charge the offense, removal is a possibility. If you charge something less, conduct unbecoming or poor judgment, you don't charge what actually occurred, that's when the ability to discipline is limited. And that's the concern we found, as you know, in our report.
Thank you.
Thank the gentleman, both from South.
And Chair will now recognize himself for 5 minutes. Mr. Ragsdale, I'm not going to spend my 5 minutes debating statutory construction with you. There's a statute that says shall be detained. That just does not strike me as being an ambiguous statute. To my friend from California's point, there is another statute which is much more narrowly drawn. In fact, it's so narrowly drawn that it says to meet a medical emergency or necessary for a legitimate law enforcement objective. I think you'll agree that's much more narrowly drawn than shall be detained. So, since I know you agree with that, what percentage of those that are apprehended at the border are detained versus paroled?
Last year we had about 220,000 bookings from CBP.
What percentage would be detained versus paroled?
About of the 220,000 bookings, it looks like about 25,000 were paroled. It's about 10%.
And so of that 25,000, you mean all of them can meet that very precise exception, medical emergency or necessary for a legitimate law enforcement objective?
Well, so again, if you're talking about parole, in other words, 212D5 parole, and I certainly don't want to debate statutory construction with the chair, but urgent humanitarian needs and a significant public benefit is a balance. The needs of the individual and versus the needs in terms of us balancing our resource requirements. If we look at 460,000...
Does the shall be detained statute contain that same balancing?
Well, so there has been a fair amount of litigation about what shall means. We see it in the Ninth Circuit, we see it in the Central California. Believe me,
listen, no disrespect to my friends from California, but you're going to have to cite me something other than the Ninth Circuit. I don't doubt that the Ninth Circuit can't define shall. I do not doubt that for a second. The rest of the country does know what shall means. So, because I'm not going to debate statutory construction with you, I want to ask you this. Of those who are paroled, I prefer the phrase bond, but paroled, is there a bond? Is it a surety bond? Is it a PR bond? What ensures that they will come back?
So immigration bonds are posted in a variety of ways. They're normally cash bonds. Again, if it's someone who has been apprehended between a port of entry, found to have a credible fear, is issued a notice to appeal.
Who determines that credible fear?
The Citizenship and Immigration Services.
I have seen juries struggle for weeks and months to determine credibility. How long does it take them to ascertain whether or not someone is credible?
I would have to defer to my colleague at CIS.
Well, while you are deferring, I want to ask you about a memo that was produced to the committee surreptitiously. This was a form that was being completed by an agent, and a supervisor wrote this at the bottom of the form. We're not investigating potential fraud, we're adjudicating asylum claims. Do you agree with me that that is an oxymoronic statement?
I'm not familiar with that document.
Well, no, but you're familiar with the sentence because I just read it to you. We're not investigating potential fraud, we're adjudicating asylum claims.
I think inherent in the adjudication is detecting fraud.
Pardon me?
I would say inherent in the adjudication is
So would I. So would I. So why would a supervisor write?
Parliamentary inquiry, Mr. Chairman. What document are you referring to, and does all
A document that's been produced to me and another member of the committee in confidence.
Would it be possible to share that document with other members of the committee?
I'll be happy to ask the source of the document whether or not he has any objections to that. I do not. I'm not going to endanger the confidentiality of this whistleblower, and I know that my friend from California would not ask me to do so. But I do find it striking that a supervisor is saying that we're not in the business of investigating fraud. We're here to adjudicate asylum claims.
Mr. Chairman.
That just strikes me as being an oxymoronic statement.
Mr. Chairman, you are a attorney, proud attorney, I'm sure, notwithstanding the comments that were made earlier by Mr. Shavitz. But I know that you understand that rank hearsay, just hearsay on top of hearsay, copies of stuff, it's just not good, reliable evidence to
Well, reclaiming my time, Mr. Johnson, I'm happy to run through whatever exception to the hearsay analysis you want me to go through, but you and I both know that there are, last time I counted, 24 different exceptions to the hearsay rule,
And
so
this
I'll be
particular
happy to
document
debate that with
fits
you
none
some
of
other
them.
time. You are welcome to ask for a second round of questions, but I'm not going to spend my time debating hearsay exceptions with the gentleman from Georgia. What I am going to ask Mr. Axel is this. What is the punishment for falsely asserting that you have a credible fear? What is the sanction? What is the disincentive for asserting it when it's not true?
An immigration judge can make a frivolous asylum finding when they get to the ultimate asylum adjudication.
And the sanction is what? That you're not going to benefit from your false assertion? Is there anything else
or
that
any other
happens?
immigration benefit for that matter.
So if you weren't going to win if you told the truth, and you're not going to win if you don't tell the truth, what's the punishment? What's the disincentive for that chart right there?
Well,
because you and I both know the cartels are not more dangerous now than they were 5 years ago.
Well, let me make it clear that we spend 25% of our criminal investigative hours on narcotics cases. We take that very seriously. It is the biggest piece of our investigative portfolio. So we are like I say, very much concerned about the drug cartels.
Well, walk me through that credibility assessment then. Somebody says that I have a credible fear of the cartel. You can run an FBI check. I don't think the FBI keeps crime stats in Mexico or Guatemala or Honduras. So how do you do it?
What I'm saying,
walk me through it. You brought it up. Walk me through it, Mr. Ragsdale. Walk me through your investigation of credibility when you can't use U.S. law enforcement to do the investigation for you.
We do not do the adjudication for credible fears. Citizenship.
Are you familiar with the process that is used?
I'm not an asylum officer. I've never done it.
So you're not familiar with how they determine credibility?
I am familiar with the idea of credibility. As noted before, I am an attorney. I certainly know as a prosecutor and state prosecutor, you are well familiar with the concept. I certainly want, as a career law enforcement person, to want people to tell us the truth. I will tell you that we could prosecute folks for 1001 if that's what you're asking me.
Well, of course not, because you and I both know that's not going to happen, and that's my point. There is no disincentive for claiming it, even if it's not true.
The Immigration and Nationality Act does provide for a sanction. It's a frivolous asylum finding. That is the statute.
Which means what? That you're not going to be successful? Well, you weren't going to be successful if you told the truth.
For that or any other immigration benefit for the rest of your life.
If you fail to show up on bond or what is called parole in the statute, is that any negative inference with respect to the subsequent hearing on the merits?
Immigration judges are the ones who are the fact finders and deciders of hearings after.
I'm asking you, and if you don't know, that's fine. Is it something an immigration judge can take into consideration that a person failed to keep their appointed court date?
An immigration judge could take everything into consideration.
Do they take that into consideration?
Sir, I'm not an immigration judge. I would only be speculating.
Mr. Chairman, I have waited patiently as the red.
Well, Mr. Johnson, with all due respect, had you not interrupted me, the red light would not have come on. So I'm gonna handle it the way I want to handle it. And if you'd like a second round of questions, I'm happy to entertain that.
Yes, I would.
Be delighted to. I would now recognize the gentlelady from California.
Thank you. I'll now recognize myself for 5 minutes. Mr. Doherty, what do you believe Congress does not have a right to see?
I have full respect for the oversight and the constitutional duties of the Congress with respect to that. So I'm not sure exactly.
Is there anything that you believe the Congress should not be able to see?
I believe that when we're going through a process of trying to figure out records, how we all can accommodate each other's sort of interests in making sure that Congress is able to do their oversight job fully, completely, and unhindered, and at the same time recognize to some extent some of the considerations, the interests that we have as an agency, particularly since we owe our people some privacy.
Would the gentleman
from South Carolina?
Would you agree Congress created the whole Inspector General apparatus? That's not constitutional in nature. It's statutory, right?
I would agree that Congress not only established the IG, they established the United States Secret Service in 1865.
All right. Good point. We did both. So Congress, if they wanted to, could do away with all the Inspector General's next appropriations process. If they wanted to. They don't, but they could, right?
I understand.
So why would Congress have to wait until an Inspector General concludes an investigation before Congress can get in line to gain access to information?
What information are we talking about?
Any information.
Yeah, Gowdy.
It is routine for people to sit at that table and say, we cannot cooperate with an ongoing congressional investigation because there's an ongoing Inspector General investigation. It is routine for that to come from witnesses at that table.
The information under both the February 2015 letter and the June 2015 subpoena has been substantially complied with, but for one, document production, and also the ultimate.
What is your, why not complete production under the subpoena as opposed to substantial? Why do you get to make that determination?
I'm not making that determination. What I'm saying is basically
the Secret Service, has the Secret Service fully complied with the duly issued subpoena from Congress?
We continue to owe you materials. We have been doing.
When are we going to get it?
Well, first of all, it's been the committee that basically inserted additional document requests that they prioritized over this.
It was issued in June, I believe.
It was issued February and June, yes.
Okay. So why have you not fully complied with it?
It's tens of thousands of documents. We are relatively one document productive way.
You are taking extra time and work. I'll give you an example here. In this particular document, just on page 4 alone, there's 21 redactions.
I don't know which document you're referring to, Chairman.
All right. We tried to do this. This is the Bartlett file. Why do we get redacted documents?
I have not seen that document, so I can't refer to that document.
Go ahead.
Specifically.
I'll show you a copy of it.
What I'm saying, Chairman, is
why should I get any redacted documents? To my original question, what is it that Congress should not be able to see?
So even on Wednesday and Thursday of last week, I was sitting down with committee staff to try and resolve this issue.
You don't want to go there. Mr. Doherty, you do not want to go there. I want the documents. We have a duly issued subpoena, and I expect you to fulfill it without redactions. If you think there's a justification for redaction, tell me now.
So the anonymous document, the anonymized document that we gave you, which lays out sort of all the various sort of categories of information about these particular files, and we gave that to you yesterday. We thought that that would help you be able to sort of parse out and target what particular files you particularly want to discuss in more fully in an informed way.
You are making decisions that you should not make. When I issue a subpoena, you should fully comply with it. It's not optional. You don't get to parse it out and hide things. When you have 79% of the Secret Service saying that your senior-most leadership is not honest and trustworthy, we have a problem. Then we're going to go peek under the hood. When you have more than 10% of your level 15, GS 15 and above, who have problematic backgrounds in that they've had to go through investigations of themselves since they've been agents, you have a problem. When you hand us a document with nearly 30 people and only one of them says it's unsubstantiated, we have a problem. When you have Cartagena happen, and there are 8 incidents since Cartagena, and then they continue to get promoted, at least I think it's 5 of them continue to get promoted, we have a problem. We get to do an investigation. So to my original question, what is it you think Congress has no right to see?
Chairman, we're trying to basically sort of lean forward. And I'm looking at the...
My simple question is, are you or are you not going to comply with the subpoena?
And that is why we were having a discussion with staff.
I don't want to have a discussion anymore. We've been talking about it for nearly a year. I want the documents. Are you or are you not going to provide them?
And there was discussion on the table in which to accommodate that. But the list that we gave you...
You really want to have you want to talk about the discussion that you proposed?
Would the Chairman yield for a moment?
Yes.
Just humor me and give me an idea of what those discussions would be about. What privilege are you asserting that would prevent you from making information available to the entity that created your department, your agency?
So I'm not standing here in a position as an attorney here because I've not served in that role at the Secret Service in a very
Well, that's
long time,
okay.
since 2003.
You don't have to be an attorney to know why you're not turning stuff over.
I'm not asserting a privilege, Mr. Gowdy.
Well, if it's not a
What I'm
privilege...
effectively doing is having a practical discussion about the information that furthers and advances the committee's oversight.
All right,
and effectively bringing us to a positive.
I want you to hear those words from our standpoint. Let me tell you what I hear when I hear you say that. We're going to decide what we think you need.
And that's not...
So, that's what you just said, that advances the committee's work. We may get to decide what advances our work. Would you give redacted documents if it were a grand jury subpoena or a court subpoena? If that branch of government sought documents, would you go through and redact them before you gave them to a judge?
I think that's a good example, but I'll take a different example. That is in terms of normal discovery. Oftentimes, courts will say we're just generally decide.
Please tell me you are not treating Congress like a criminal defense attorney. I am begging you to please tell me that's not what you're doing.
Mr. Gowdy, what I'm saying is basically the discussions that we had as late as last week, I thought we're going towards a creative resolution to this particular issue, what ultimately was going to give the committee the place where they wanted to be on this.
Well, but what I hear the chairman saying, what I hear the chairman saying is the place he wants to be is exactly what he asked for. Hence, there really is no more need for negotiation unless you have a legal privilege or some constitutional precept you are standing on to not allow the branch that created your agency to see documents. Then what is the discussion about?
The discussion is about ultimately what is fair to individuals as well. Look, if you have a child come home and basically they do a fender bender, you basically sort of put them on timeout or whatever, and then you ultimately give them the keys back. This is exactly the same situation. We have individuals who have engaged in misconduct, but it doesn't mean necessarily that's the end of their career. They basically continue to go forward, just like we treat our children.
Well,
that's basically what we're talking about.
Don't you think the father of 3 would be able to appreciate that analogy? Then why can't you give us the documents and then make the analogy?
Let me recognize the ranking member, Mr.
Yeah, I just want to make sure we don't keep. It seems like we're going in a little circle here. I want to get us off from the circle. Who makes the decisions with regard to the redactions? We're all concerned about Congress being able to do its job, and to do its job, we need information But who makes, when you said you're not a lawyer, I know a lot of people have a lot of against lawyers, but we have been provided with special skills and information that a lot of people don't have. So you're not a lawyer, is that right?
I'm a lawyer.
You are?
I am, yes.
Okay. And so tell me, who makes these decisions with regard to the redactions?
It's a combination of decision with...
Do you make them?
I do not. And that's not the role that I've played in, sir. I actually came here to talk about PMP and the Hoger Committee report and not this, because this is an area that I've not been involved in up till now. I don't play an official role in this. Played an official role in building up the new integrity system and the new table of penalties, but not the old disciplinary system that we had before.
So who can we talk to get you don't sound like you're the right person to be asking these questions. Who should we talk to get the answers to the question?
This is a joint decision.
This is legal counsel for the Secret Service and legal counsel for DHS?
Legal plays a very large role in the decision-making, yes, sir.
All right, I got to conclude here with this line of questioning here to tell you how highly offensive it is to you comparing this to a fender bender, okay? When you have 79% of your employees saying they don't believe that the senior management is acting honestly, don't tell me it's some fender bender. This so-called employee number 5, an SES-level employee, transmitted hardcore pornography materials along with racially charged and sexist conduct, and yet he only received a written reprimand. You have another. Here's an email I'm gonna read to you as best I can, and sorry for the nature of this. This is subject, a very talented woman. And remember, this is on government computers between employees. Now this uses the B word, has some talent. Careful where you open this, definitely adult material. And then it goes on. But you've redacted all of this. I can't tell if you're actually taking the appropriate disciplinary process. And don't tell me this is some innocent fender bender where we didn't take away the keys the right way. Get serious, Mr. Doherty. This is serious stuff. And if we can't trust the senior-most people in the Secret Service, you're right. They're going to have to lose their keys to the kingdom. And I don't think you're taking the appropriate disciplinary action, but I want to find out. I want to know. I want to look at those files. And guess what? That's the way the Congress is set up. And when you have more than 10% of your SES employees, 15 and above, that fall into this category, you have a very serious problem. I could go on and on about the serious nature, and when you send me a spreadsheet with 30, and none of them only one of them says it's unsubstantiated, we have the right and the duty and the obligation to look at it. That's what oversight is all about. This committee was formed in 1814. Abraham Lincoln served on this committee, for goodness sake. So unless you have some legal authority, you are putting us in a position that nobody wants to be in. We don't want to have to hold you in contempt. You should cooperate. And of all the things out there, Homeland Security, Secret Service should know, you wouldn't put up with this if you were investigating somebody else and you had a subpoena and you served it on them and they said, give me a moment. I got to cross out a few things because I just want to make it fair. I just want to cross these things out so that, I want to make sure that you get what you need. Are you kidding me? That is not the way this process works. You have a duly issued subpoena. I expect you to comply with it. When will you give me an answer as to whether or not you're going to comply with the subpoena in its totality? Not a negotiation, in its totality. When will I have that answer?
Chairman Chaffetz, I'm not in a position to tell you that.
You knew this question was coming. We told you in advance it's coming. When is it reasonable for me to have an answer to this question?
I think we are working very hard on that at the latter part of last week, and hopefully we can get to a place.
Give me a date.
I cannot give you a date, Chairman Chaffetz. I'm not the decision maker here. But I think
who's the going back to what Mr. Cummings says, give me specific names. Who advised you on this question? Who?
Well, it's ultimately...
No, I want to know specifically who did you have a discussion about this with. You're under oath. Give me the answer.
With respect to multiple individuals.
Go ahead. List them out. I got time. Go ahead.
Director Clancy, a number of other individuals.
No, name the individuals. You're a smart man. You know these people's names. Name them.
The gentleman directly behind me, Mr. Paramore. Our counsel, Donna Cahill. Those are the individuals.
Those three, nobody else.
That's what I recall.
Any other, I'm giving you one more chance. Anybody else advise you on how to?
Do not recall, Chairman.
Okay.
This has been a multi-pronged discussion, and I've had multi-pronged discussions with your staff on this issue to try and sort of find a way forward.
Yeah. It's not acceptable. We shouldn't have to wait this long. We're trying to do our jobs, and we're trying to help you to do your jobs. But it requires cooperation. And when I have to get to the point where I have to issue a subpoena, I expect compliance, 100% compliance. Understood?
Understood.
We'll now recognize, we'll now recognize the gentleman from Wisconsin, Mr. Grothman, 5 minutes.